Also, Alan Jacobs was chairman of the British Friends of the Hebrew University. And of course, our speakers who I will introduce shortly. In any case, it gives me sort of hot on the heels of a quite large event that we held yesterday, the 75th anniversary of the Hebrew University Faculty of Law. And we consider this year's Lionel Cohen event as part of those events the day after. It gives me great pleasure to open the 2025 Lionel Cohen Lecture, which is in this year not a lecture, but rather a dialogue, or and at the end of June, it's difficult to talk about fireside chats, but a kind of fireside chat on a topic which is actually at the heart of the history of the Lionel Cohen Lecture. And in advance, I'd also like to say that in this quite large forum that it can also be a discussion. So if David and Dorit are comfortable with it, then please raise your hands if you have a question or a follow-up comment, as we would normally do, I think, also in our faculty seminars. The Lionel Cohen Lecture is perhaps the Faculty of Law's most important and regular, prestigious annual event. The first such lecture was delivered in 1953, close to the graduation of the first class of the faculty. And we have to sort of reimagine the establishment of an annual lecture and to think about 1953, when, as we discussed earlier, for all intents and purposes, Israel was sort of still subject to the, not the jurisdiction, but the jurisprudence of the House of Lords. At the time, this was clearly an important venture to celebrate and discuss the unique relations between the British and Israeli judiciaries and legal communities in general. And this indeed is a central part of today's theme of the discussion. The list of Lionel Cohen lecture delivers addresses includes a very impressive collection of lords and barristers, and we are delighted today that Lord David Pannick, as well as former Chief Justice Dorit Beinisch, will be joining this list. And together they will explore the common law tradition, which is a major basis of the Israeli legal system to this day. And in today's complex times, the relations span many other areas of mutual interest. A few words about Lord Lionel Cohen, after whom this lecture series is named. He was born in 1888. In 1943, during the Second World War, he was appointed as a judge in the High Court. He was then appointed to the Court of Appeal, and in 1951, he was appointed a law lord, entering the House of Lords, where he served until his retirement in 1961. We also have the honor and pleasure of hosting today two grandsons of Lord Lionel Cohen, Jonathan Cohen, who will briefly address us in a few minutes, as well as William Cohen, sitting in the back row, a backbencher, so to speak. Lord Cohen also chaired many royal commissions in the years following the Second World War, particularly in the areas of company law and compensation. The trustee of the Lionel Cohen Lecture Fund is currently Sir Jonathan Cohen, King's Counsel, himself a High Court judge, educated at Eton and the University of Kent. Jonathan Cohen was called to the bar by Lincoln's Inn in 1974 and took silk in 1997. He was appointed a Justice of the High Court and knighted in 2017. If any of that is incorrect, then feel free to correct. And as I mentioned, we are doubly pleased to have William Cohen, also a grandson and currently president of the Global ICA, attending today. To briefly introduce our speakers, who in the classical statement need no introduction, but nevertheless, we also have an audience online with live streaming and recording. Dorit Beinisch, also an alumna of the law faculty from 1967, is the first woman to serve as president of the Supreme Court of Israel. from 2006 to 2012 and served as a justice of the Supreme Court from 1995. And prior to joining the court, she served in the Israeli Ministry of Justice for many years, also as State Attorney of Israel. Lord Pannick, or Baron Pannick, I'm not sure which takes precedence, also King's Counsel as a crossbencher in the House of Lords in Blackstone Chambers, and a fellow of All Souls College, Oxford. He is a renowned practicing barrister who has represented in numerous high-profile cases, which perhaps we should have a session just in those cases at a certain point. So thank you very much to everyone who has joined us today and anyone who is also viewing us online. And it's my pleasure to invite Sir Jonathan to the podium, or you can speak from there, whichever is.
I'll speak from here, so I'll be very quick. This lectureship was set up in honor of William and my grandfather, who was the first practicing Jew to make his way through the upper judicial ladder to his appointment in the House of Lords. And I think that the lectureship was set up at the Hebrew University because he was a very good friend of Norman Bentley, who will be known to some of you as the Attorney General during the British Mandate and the founder of the university. And they were very good friends. I remember meeting Norman Bentley in 1959. I was a very small boy then, and I went into his hall, and it was just covered with books from wall to ceiling along, from floor to ceiling along both corridors, and it made an impression on me that I have never forgotten. The lectureship is almost exactly as old as the law faculty. The first lecture took place in 1953, which I gather was the first year that students graduated from the law faculty of the Hebrew University. So there's a lovely parallel between the two events. And it would be quite wrong for today to pass without me saying mazel tov to the law faculty on its 75th anniversary, to the Hebrew University on its centenary, and next year for the centenary of the British Friends of the Hebrew University. So our roots go very deep. Finally, I just want to say something. These events don't happen without a lot of hard work, particularly to Toria Hassan and Ruth in November, who have all been we have 14 brothers, which thank you very much, and thank you in advance to David and Dorit, without whom, of course, none of us would be here. Thank you.
Yeah, well, thank you very much. Thank you very much, Jonathan. It's a great pleasure to be here. Dorit, we're going to talk about the relationship over the years between the English legal system and the Israeli legal system. We thought, Dorit, that was an appropriate way to celebrate the 75th anniversary, because the purpose of the Lionel Cohen lectures over the years has been to reflect on and to celebrate the links between the English legal system and the Israeli system. And Dorit, there's no better person, we thought, than you to. And you were available. And there was no better person to reflect. Of course, you don't go back, I should emphasize, to 1948, but you go back a few years. And shall we start at the beginning, which is not, as the Dean suggested to me earlier, Genesis, but let's start more recently, 1948, long before your legal career. But I'm right in thinking that in those days, many of the judges and the lawyers in the New Israel had been trained in law in the United Kingdom, in London.
Of course. Yes, the first president was Justice Ocean, and later, even later, especially when we sit here and Pershing, all of them. Landau was the president of the court. They all there were trained in England.
And when you started out, what sort of textbooks, legal textbooks, would you have on the shelves in the offices where you were working? Were they Israeli? Were they English?
We had no Israeli, I must say, and it wasn't 48 when I started. It was long ago. So then, I think everything was only English textbooks. It was someone under students. It was Archibald in the criminal procedure. It was Williams in criminal law. Everywhere, of course, torts, evidence, all the books. And talking about administrative law, nothing was. It was the Smith that we opened before every case we came to the court when I argued in the court for administrative issues. First of all, the Smith, Wade, only, I must say, all our textbooks were in English. So practically you could say that even in the 60s, what I'm talking about, the training was actually on English.
Yeah, that sounds very different from being trained as an English lawyer in England. I mean, those were the textbooks that I would use a little bit later, but not too much later. When I was, do you think there's an irony here? Because 1948 was the culmination of a struggle, an epic struggle for the independence of Israel from the British Mandate. And yet, in legal terms, the influence of the United Kingdom of London persisted for many, many years. And it is quite extraordinary. I mean, prior to independence, long before the memory of anyone here, the final court of appeal for the British Mandate was, of course, the Judicial Committee of the Privy Council, which then sat until 2009 in Downing Street. And so the appeals would go from here to London. I've done my research. There's a Judicial Committee case in 1926, Jerusalem Jaffa District Governor versus Suleiman Mara, where the Privy Council held that by reason of the League of Nations mandate for Palestine, His Majesty had jurisdiction over Palestine, and so the Privy Council was the final court of appeal. And they decided, the case was about the district governor having power by ordinance to take water from the springs of Urtas village for the purposes of the inhabitants of Jerusalem generally. And the Privy Council, a remarkable institution, because in those days, it was the final court of appeal for much of the world, for India, Canada, Australia, not just Palestine. Remarkable.
It is. When you think about it, during the British Mandate, while the Jewish population was fighting against the Brits, actually accepted the British system and respected it. I think it started really before the state was established. When Cohen had the idea of the English law, he admired it. He was there during the war, World War II. So in the history, it's kind of strange. I thought about it. While fighting, all of the basis for our law. All the ordinances were expected. And of course, we will talk about it probably in reference to the judgments, the British judgments, to the common law, to equity principles. It was all accepted and very naturally accepted. And some of the ordinances are still here, they still exist. So yes.
I mean, it's rare in my experience for judgments of the Israeli Supreme Court to be referred to in judgments of our appellate courts in London. It does happen. I mean, the most celebrated, the most often cited, I think, was Justice Barak's judgment on torture, which has been cited in a number of cases. But other examples, I mean, 2 years ago, I was arguing for the government in the case where they wanted to remove asylum seekers to Rwanda. And the Supreme Court, our Supreme Court in London, was very interested in the Israeli experience. And we cited the orders that had been made by the Israel Supreme Court. I don't think there was a narrative judgment determining the issue, but there were procedural applications. This is still the case in your experience over the years when you sat as a judge that contemporary judgments in London were still cited in Israeli courts?
First, I think they're still cited. When you say how our judgments were cited, I remember once I was very impressed that you asked me, what do chicken growers have to do with constitutional law? Someone, I don't think in Congo somewhere someone cited the chicken growers.
Yeah.
And they did ask me what they had to do chicken growers with constitutional law. So we had it.
And there was another case about prisons where
Privatization of
I think it was your judgment, wasn't it? Privatization of prisons, whether that was constitutionally appropriate. That was relevant in an English court. So the English courts are willing, eager to learn from Israeli Supreme Courts. In Israel, courts' decisions in London are still cited.
The thing is, I think things changed until 1980, or that we were really, even by law, connected to the judgments and the principles of law coming from the directive because of Article 46, King's Order in Council, Palestine that was enforced. So we were bound by it and we respected it. We accepted it. That's what I said, always good. The British courts citing our judgments, I think it became showing interest in our judgments. It became stronger when we had the exchange between two delegations, the judges from England and the judges from Israel. We met every year, actually, once here and once there, and we learned the judgments and the way of thinking of each other. And since then, your judges were more interested in our judgments than before. So the ship changed later. But we still, I must say, even the fact that in the last 30 years, if we can say so, we refer more to American cases, Canadian cases. This is a change in our.
And why is that? Why does Canada and the United States become more prominent in terms of Israeli law?
It's complicated. In short, I would say like that. Maybe people sitting here are to blame because the academics went to the United States and Canada. Canada was also because when we introduced the law of human rights and dignity, we were influenced much by the Canadian Charter. So we introduced more Canadian cases that interpreted the Charter.
Yeah.
But America, very simple. The academics went to study in American universities. They were interested in articles that are published in the United States. They had to publish themselves. I think now, I'm not sure about it now, but at that time, this is part of it. Part of the development. I mean, of course, what I said before, we were trained actually even with, not in London here, by English law. This made us a common law. We are a common state since then, actually. But we had access to the American judgments and things were changed, as I say, maybe people here can explain it better, but I think this was the beginning of the connections with the United States and Canada and changed And the judges of the last 20 years were not really trained in England anymore. So it's the legal training was changed and the legal way of thinking. We were more open today also to the continent in certain issues, but this is part of the change in our legal, and I think people here can tell much more than me about it, how it happened.
But I mean, despite that thing, my perspective is that the English legal system and the Israeli legal system still retain and value very similar principles of law. I mean, one can state obvious ones: independence of the judiciary, the rule of law, the protection of human rights, the need to prevent corruption by officials and by ministers. And from my point of view, but these are theory. I mean, these are principles. Whether they're respected or not is another question. But there is, it seems to me, a recognition that these principles are fundamental to a legal system, and they're common law elements. No doubt they're also to be found in the United States in principle and in Canada, but that's because they have been affected. But that's true of Israel, is it not? I mean, despite the movement of
it's true. I mean, as I said, first of all, we think basically a common law state, a common law system. The role of presidents of the presidents, the rule of law, as you said, only for independent judiciary. I hope with the most democratic states in this still debate. I hope so. So, and also, of course, judicial review. After all, we took the idea of judicial review from your system, developed. I must say, it developed. It started completely, as I said, before going to the court. I used to take this meet and see what to say about this issue or the other. It was completely started, and principles of all the first. It's political rights. It's rights started not individual. This was later human rights, but with the rights, freedom of expression, and rights of association, and the press. The British ordinance of the press was abolished here only in 2017. Until then, you needed a license according to the ordinance of the press. Many of them still exist. They were revised. You see, the tort law, all the torts are still, we have the same ordinance with a Hebrew and amendments, but basically it's that. And how do we have negligence? We go to Dorit, we started, and everything like that. See, when I came to argue not a very present laws against terror, of course the defense regulations from 1945, a lot of it still exists. I remember when I came to argue a case with the state on administrative detention, and then Justice Usman says to me, Beinisch, what is the problem? You have liver surgery. I didn't know who's liver surgery. What is it? You don't go to the case. It's very simple. So,
he thought he was talking about liver sausage.
No, I understood that I have a problem, but he wanted to say that I have no problem. So this is actually the case, and in many cases.
This is very true of other jurisdictions that started off with British ordinances or rules, some of which still remain in India, in Hong Kong, in other jurisdictions that where independence was gained, and the principles are developed. They're developed according to national characteristics, but the basic principles you make. I mean, there's one fundamental difference in criminal law which is, you don't have juries, do you? I mean, juries in England, they're sacrosanct. And every so often, there are political proposals that the jury trial could be cut down, often for financial reasons to speed up. And it's very sensitive at the moment, but again, you don't have.
Luckily, we don't have the jury system, and this is also the Brits to blame, because they didn't trust the population. So they thought it was the idea, of course, the jury system is a democratic idea. The people are involved. But who are the people then? When you have the Jewish population, the Arab population, and the British?
The British didn't tell you that Lord Devlin said that the jury system is the lamp by which freedom lives. Didn't tell you that.
No. So they didn't accept it, and this is the reason, historically reason why we did have the jury system, because the basic idea of a jury didn't exist here during the British Mandate. And so they had the professional judges, and you mentioned Privy Council and other. When it came to London, it prevailed. The government was always right. Here, the Supreme Court was more a professional Supreme Court, but most of the judges were British at that time. Again, they didn't trust the population.
You've got a question.
Not a question, a comment.
Comment. All well.
Yeah, it's a main professor.
Thank you. So I agree that in some areas like tort law, we are still part and parcel of the common. But this is not true in many other instances.
Oh,
good guess. That's my area. I mean, especially in private law, we are a mixed system. And so we have influences from both civil law and common law systems. And even more importantly, now that we are that we came of age, we are an independent legal system. Unlike the Israeli system 30 or 40 years ago, we are an independent legal system. And so we are inspired by any other legal system that we can rely on, including the British, but we don't give any special status.
No legal system is an island entire of itself. All legal systems are influenced, affected by issues in other courts. And it's true here, isn't it, as it is in England, that very similar issues arise, whether it's private law or public law. I mean, we all have cases about how do you deal with terrorism and reconcile that with human rights. To what extent do you defer to the executive in judicial review because they may have expertise in relation to particular topics? And the case law of different jurisdictions is not binding, but it does influence the court.
Well, we are the champions of people. Thanks to our relatively young age, we are the champions of comparative law, more than any established legal system.
Because you are affected not just by the common law, but the civil law tradition.
And because we don't want to reinvent the wheel.
Yeah.
Yes, but yeah, it's true where we have our legislation. So in private law, we have more, as you said, and in public law, we developed, we did remain in the British way of thinking, and of course, of actions, but basically, public law is based still on the context of the groups. I think so.
Yeah, of course.
If I may add, I taught a few years in the UK, and I was always interested in administrative law. And teaching in the UK was very easy because all the grounds were similar. The thought was different, but I felt that Israel had developed some of the grounds in directions that the British system still hadn't done that.
We were quicker in that.
Yeah. Yes, we were earlier before they United States. But there was such a similarity, there still is. I explained in the class how our grounds develop on the basis of the British system of legality and how they grew and developed and flowered or whatever.
Yeah.
But it's still very, very similar. So it depends if you're talking about public law.
It's also, it's a cultural thing, isn't it? It's the extent to which a legal community is open to influences. And I think my perception is that the Israeli system is particularly open to the experience of other jurisdictions by way of information, whereas, at least until recently, and perhaps even now, the United States system is a very closed system. You very, very rarely see counsel in a Supreme Court case, constitutional case, cite the experience, they may be on a very similar issue, of the European Court of Human Rights, or the Supreme Court of London, or of the Israeli court. It's a cultural thing, in the same way as the Americans don't join international organizations. But my perception is Israel is open to these influences.
Every legal system is, of course, inspired and developed through the culture, the history, the background of the state. Of course, the American, they want to make America great again all the time. So whatever they really don't accept, you don't cite judgments from other systems before. They don't in their judgments. Some of them, very few, and I don't know how now, but we did it. But this is different the way we were, almost every issue, everything that comes to the court, we start to think, and how did other countries solve the problem? And we have all similar problems, of course. So this is basically not only for the judges.
No.
When they argue a case in court, they have to bring, if they have examples to show how other systems don't, they do it. And
Do you have another comment there?
Yes, I just a couple of comments about during the first decade of Israel, they were completely citing British authorities, but we translated them. You read the judgments of it. That's the thing. First decade was very important for the Israeli court, for the Israeli society to talk Hebrew, the sign of independence. So you could see the English judgments translated, cited, but cited in Hebrew, and then they figure out that it's too costly or too cumbersome or whatever, and then they move to straight citation in English.
they're less,
We get more confident about language, perhaps, or whatever. Second is about the Americans. Paradoxically, the Americans are not citing any authority. But the American administrative law, American administrative law, is back to the good coronavirus is they just don't call it, they call it major question. It's the same principle.
Yeah.
So the English principle of legality is basically, I think, controlling the world of public law. In Israel, it gained constitutional status by recent decision of the Supreme Court, and not only. This is even if you don't cite UK authority, the idea of legality as such is probably the UK ideology of ultra-vires ideology. It's probably the ideology that controls most of almost any system around it, not as a constitutional system.
Yeah. I mean, on constitutional principles, which you turn us to, there is, isn't there, Dorit, a real distinction between the United Kingdom and Israel in that we have in London checks and balances which are very effective in practice. We have a second chamber of parliament, the House of Lords, which has considerable delaying powers and considerable powers to make the government think again and to raise issues which the government may not want to consider. And that is a very real effective control on arbitrary power by an executive which controls the lower house of the legislature. You don't have that, do you? You have a unicameral legislature, which makes the role of the other main check and balance, which is the judiciary, even more important.
Of course, we believe in it. That this is the only institution that can review and to protect the checks and balances. Problem that it's not accepted so much, not by the executive and not by parliament, who is of course controlled by the government because of coalition. So it is true, but I agree on that. Basic public law is really we have in common with this or the Commonwealth states and the British and the States and Britain and Canada. We are all, I think, on the same basis, even if it developed. Listen, one of the David, one of your cases, when you got, I was very much impressed by this case, and I think you are with this case, when the court gave an order to convene the parliament after by the Queen has signed it, and
Boris Johnson, as Prime Minister, prorogued that is suspended Parliament because he thought that was the best way to get the Brexit deal done. And the Supreme Court unanimously, which is unusual, and 11 of them, they were sitting on bank, they decided that the advice to the Queen was unlawful because it was unconstitutional, and although Boris Johnson had suspended Parliament, that was invalid. Parliament was still sitting. So
to think they went much further than we would do, I think, with such a decision.
There are many people in London who think it would be in that case, there was no effective evidence on behalf of the government as to why Boris Johnson had suspended Parliament for so long. And the rumour, I never got to the bottom of it, but the strong rumour was that there was no civil servant who was prepared to swear an affidavit along the lines of what was needed in order to defend the government's case.
And then for the court to decide that the Queen was misled by the Prime Minister is very, very it happens. So even that we think that we are going forward very rapidly, I'm not sure how much we do, but we never thought that the British will do it. But when it's needed, and when you argue the case, it works.
Well, I mean, these are profound constitutional questions that are right at the edge of constitutional law. They arise in England, as you explained, they arise here, they arise or might arise in the near future in the United States, because the founding fathers were confident, weren't they, that there may well be an imperial president, but the checks and balances will control him or her. And the checks and balances are Congress, which may or may not do its job, and the Supreme Court, 3 members of which have been appointed by the president. So we will see, but it's worrying, very worrying.
It's worrying, you know, always I used to bring it an example that they have checks and balances, not only that they have the Constitution, but as you say, they have 2 houses of Congress and there is the Supreme Court, so the president cannot do everything. But now we see that it's possible because the justices were appointed by the president, a system that our government already tried, and I hope will not stay implemented, political nominations by the president. He controls the Senate and the House of Representatives, so the Congress. So the checks and balances, only the federal system may save it this way or the other.
And you can never be sure what a judge you've appointed is going to decide. It may be that, for example, Chief Justice Roberts disappoints President. He wasn't appointed by President Trump, but no. He's generally a Republican supporter. And there's a famous story, isn't there, about Eisenhower, who said he made 2 mistakes as president, and they're both on the Supreme Court. That was Warren, yeah, he appointed Warren and Brennan as well, I think. But let's have another question. Yes.
Judicial packing in the UK and it's a very dominant political force to pack the Supreme Court as well as it is in the US. Maybe you can reflect, because I think this is one difference between the two systems that for me happen to be.
It's just not an issue. It is simply not an issue in the United Kingdom that people are appointed because of their politics or because of how they are thought likely to decide cases. I can't remember an example in recent history of that occurring. In the past, in the beginning of the 20th century, perhaps, and there were famous examples where conservative Lord Chancellors appointed very radical people. Stephen Sedley was a radical lawyer who was appointed to the High Court bench. The only example I can think of was John Donaldson, who became Master of the Rolls, Lord Donaldson. He had served as the president of the then National Industrial Relations Court at a very sensitive time for labour relations. And he was thought by the trade union movement to be very hostile to them. And he was not promoted until Margaret Thatcher became Prime Minister. So they're very rare examples, but the English legal system has many, many problems, but that is not one of them, happily, not one of them. And I won't comment on Israel, but I think it's very, very unfortunate when appointment of judges becomes politically contentious, because it undermines not just the vital function of the independence of the judiciary, but it also inevitably undermines the confidence that the public have in the ability of the courts to render impartial and independent judgments.
But that to do with judicial review, the UK as opposed to, let's say, the US or Israel, where it's a very contentious issue. But how come in the judicial review kind of a judgment that the UK Supreme Court, because once you begin to do intensive review, then this inevitably is
we have a very British compromise, which is that the courts cannot overturn legislation, which you can do here, but they can give a declaration of incompatibility, that they think that the legislation contravenes the Human Rights Act, but it's then for the legislature to decide what to do about it. But despite that power, the judges in the United Kingdom have remained politically neutral, at least perceived as such. And I know many of these judges very well, but I wouldn't be confident as to how they would vote. And I certainly wouldn't be confident how they would decide a case when I argue before them. Whereas I think if you're an advocate in the United States, you know very, very well in a constitutional case how at least 7 of them are going to decide the case.
This is why, David, you gave us the reason why we have to stick back to the British system and not to the American system. Really, part of the culture was for the independence of the court, the judges shouldn't be appointed politically. Of course, reality, there is political influence, but the idea was that appointing the judges shouldn't be political. This is a very, very dangerous situation, and now they changed the law in Israel. I don't know what happened with it, but it will be on from the next method. Appointing judges politically means we don't have judicial independence completely. It means that in order to advance, to make any progress, every judge in the lower court has to please the authorities and the political branch. It's a separation of powers.
We made 2 fundamental changes in the United Kingdom in 2009. The first was that the appellate committee of the House of Lords, which was our Supreme Court, was abolished, and an independent Supreme Court, not part of Parliament, was established. And that was important symbolically. But the other important function was that the role of appointing judges was taken away from the Lord Chancellor, who was a member of the cabinet, who, as I said before, made these appointments in a neutral manner. But nevertheless, he or she, always a he, was appointing. And the role was conferred on an independent Judicial Appointments Commission. And that Judicial Appointments Commission has no political element to it, no involvement. The people who appoint, you have an independent chair, you have judges, you have lawyers, but the politicians are not part of it. They have a role, they are consulted, they can express a view, but they're not on the Appointments Commission. And it works. And it works very well. It means you have high quality people appointed. It means you're not appointing people because of the position they're thought likely to take. And the judiciary, I think, in the United Kingdom, others will say if they disagree, still retains the respect of the public more than most public institutions in the United Kingdom.
David, it's heartbreaking for us to hear it.
Yes.
Please take control of this.
Yes.
I would like to offer a different perspective on that. In the sense that, if I understand correctly, about 3 years ago, there was an attempt by the British government to repeal the Human Rights Act, or to radically change it in order to be what I read the explanatory notes. They say common sense judging under that, and you can understand what it means. And one aspect has to do with public opinion. You know, a similar attempt by our government was responded by a large protest, and the campaign against this attempt is so-called legal reform. Whereas, as far as I understand, in the UK, the reaction was much more mild, quite quiet in the public opinion. And the other aspect is, what do you think is the current atmosphere about this kind of populist approach regarding criticism of the court, or trying to get away with the issues of the rule of law, whether the Supreme Court would limit the power of Parliament to make these kind of changes to the Human Rights Act, things like that?
Well, you're right. There are periodic attempts to repeal the Human Rights Act and to leave the jurisdiction of the European Court of Human Rights, but we're still there. And there is an element of British politics that takes that view. It's normally provoked by a judgment that people don't like. For example, about 10 years ago, the European Court ruled that prisoners, or at least some prisoners, should have the right to vote. And this was, for reasons I really didn't understand, very sensitive issue. And the Prime Minister of the day, David Cameron, said in the House of Commons, this judgment made him feel physically sick when he read it, which was quite an extreme reaction, but there we are. And you have these movements every so often. And the Conservative opposition party is at the moment thinking, should we support leaving the European Convention? But there's very few people who object to the British judiciary interpretation of the Human Rights Act. It's normally an objection to Europe, although the judgments of the European Court over the years have played a very powerful role in civilizing English law when the English courts were unable to do so. So it is a problem. There is a populist movement. The Reform Party are popular, no doubt because of the failures of the last Conservative government and the failures of the current government to solve all the problems. A party that comes forward with new ideas is popular. But this is a constant concern. We've had the Human Rights Act since 1998. It's been there for 27 years. I suspect it'll be there for a lot longer.
Even say so, I think, I read it, no, I didn't. It is involved also with international issues. I mean, they want to be independent. This is populism. Germany and France will not tell us what to do. It's our call, it's our national call, and this is part of Brexit and part of the idea to be not connected. But so populism is now.
I don't think that's
Completely related, and that's something that we also discussed earlier. But if we are also thinking about the decline of the influence of UK law in Israel or other places, and it seems to me highly correlated to the decline of UK law in the UK. In other words, I mean, you mentioned Brexit has already been mentioned a couple of times, but you know, the UK the accession to the European Union in 1973 basically hands over. And I'm not a Brexiteer, wasn't a Brexiteer, but hands over a lot of influence, not only to the courts, but to the European Commission. So legislation and regulation in newer areas of interest. And also as a student in the 1990s, UK law became much less interesting. I was interested in European Union law because it would apply to some extent with subsidiarity and so on, but it would apply in the UK, but the action was in Brussels. So is that not part of the narrative that we should be thinking of? I mean, the Israeli competition law, the statute, is based on the Treaty of Rome, ridiculously, because the Treaty of Rome competition law deals with the European market, not with the domestic market. But of course, all the jurisprudence is based on US law, the Sherman Act, and so forth.
I mean, you're absolutely right. There is an insularity in British political thinking, which was demonstrated by Brexit. But the harsh reality for the Brexiteers is that so much of law is international. And notwithstanding Brexit, if you're dealing with international trade, or you're dealing with refugee law, or you're dealing with humanitarian law, you're dealing with many areas of law. You have to reach agreements with other countries. And that's what we in Britain continue to do. And of course, the European Court of Human Rights is not part of the European Union, it's separate. But you know, British people don't always understand that. And there is a strong feeling, why should we have our law determined by people from Germany or France or Latvia or wherever in Strasbourg? That's the feeling. But if you say to them, well, the judgments of those courts have done a great deal to change British law favourably, they will accept the judgments, but they're concerned about the principle. So you're right, people are concerned. Yeah. There's another question.
I just wanted to say that I'm not afraid that Israeli politicians would try to deprive prisoners of the right to vote out of self-interest.
There's a close interest taken in those matters, no doubt. Let's have another question. Somebody else got a question for us that we can address. Yes, or comments. Yes, please.
I just had a quick Google check, and I noticed that Israel took the idea of having an attorney general from the British system, according to Google. These days, if you want job security, the attorney general is probably not a job that you're going. And the idea, as I understand it, is that you should have somebody who can advise the government on what their legal position is. Given that that is such a perilous task these days, do you think that the days of an attorney general, certainly in Israel and perhaps even in the UK, where the attorney general is constantly under a lot of pressure, is now being kind of is more or less obsolete now? And that if the government wants legal advice, they can take it internally from the Justice Department or from their own civil servant lawyers? Or is it important actually that you see that attorney generals get into trouble with the government so that the electorate can see what the position is and draw its own consequences.
It's a very delicate issue. I don't know if we can discuss it. Yeah.
So I'll offer a view, you could say whether you agree or not. I mean, it does seem to me this is an absolutely vital position in any legal system, because a government requires independent legal advice as to the legal rights and wrongs of what it is proposing to do. And it should not be relying on civil servants, however competent and qualified they are, who are beholden to that government. They need independent advice from people of stature and status. And Dorit, that was your role when you were state attorney. You very often have to tell the government things they didn't want to hear. Of course. And you did that.
They want,
And you did that it was an absolutely vital function that you performed.
of course, and this is the whole idea, the independence, the professional independence, because they were the people who have to see to it that the government will act and according to the law. I can tell you, if we mention what we took on this issue from the Brits, we'll hear the Attorney General is really government official and belongs to the administration. But it was really always a tradition that is independent, he or she, now it's she, but we have never had it before. We have to be independent and not, of course, to act according to government policy, but according to the law, and to how to do. I can tell you that I argued a case years ago where the issue was if the Supreme Court may review the Attorney General's opinion, because the idea was that the Attorney General is independent. And we took, I think it was a British case, Postmaster or something like that, that the court doesn't interfere with the opinion of the Attorney General. Was an English case like that, and I tried to argue it in the court. This, of course, I lost. They said we, the general at the time, we are deciding this is the final word until it comes to the court. Then the court decides, I think, rightly so. So this is the legal situation which they want to change. Always, governments, politicians didn't like the function of the Attorney General or State Attorney being independent. Not, it was always, it's a natural tension. But the question comes to a point that you have to respect the legal opinion, and then it stops there until it comes to the law.
And the value of the institution is that you are performing as a lawyer in the governmental context, the function you perform for a private client, that you tell the client, whether they want to hear it or not, what the legal position is. And the Office of Attorney General in the United Kingdom has worked because the person who is appointed is somebody who is generally part of the political class or is a supporter of the government or understands governmental work. So the government has always respected the legal opinion. And there were many things that were said against Margaret Thatcher when she was Prime Minister, but those who worked for her emphasized that however forceful her politics were, and they were very forceful, she was always concerned to ensure that she complied with legal requirements. You know, she might want to change the law, but she respected the judgments of the courts, and she respected the advice that her Attorney General was giving her. And that seems to be absolutely fundamental to the rule of law.
See, this was my experience, especially with Prime Minister Begin. And he said, he said, well, if you say so, maybe, as you say, he tried to change laws, but he accepted always, respected the Attorney General's opinion. Not the only one, they all respected. And some were very bitter against it, and angry, but accepted. This was the idea, to accept. because this is the role of the Attorney General. And in the United States, it's a political, of course, political office, and when it changes, the president elected is a different one, the administration goes and the Attorney General goes, of course, also the Minister of Justice. Now, you also have order the president against all the offices where someone that was Attorney General wants to work for the other administration was working, is to close their offices. It's revenge. So things become crazy, but thanks God we are not there yet. So anyway, it was a tradition that you have to accept. Sometimes you don't like it, but you have to accept the Attorney General's opinion, and this is. Sometimes politicians say, well, but my lawyer said different. He said it's possible because they, I don't know where, Friday evening or Saturday or another day, they were discussing it with their private friends, the lawyers. But I think in general, they knew that they have to respect it. Oh.
Well, one more question?
Could you please then reflect on the current reputation of Israel in the UK? And I was, of course, given the war and the government policy, and I think that the relevant issue is whether public opinion or professionals distinguish between the Israeli government and its judiciary in terms of public reputation, because from our perspective as academics, we are subject to call for boycotts and these kind of elements, regardless of the fact that we have absolutely no influence on government policy. The question is, what is the perception of the Israeli judiciary, given the current situation in the UK regarding the reputation of Israel?
Well, I mean, certainly in relation to the government and parliament, and those who are involved in public affairs, I think there's a very deep understanding of the distinction between the policies of a government and the role of a Supreme Court and the role of academic institutions. And they well understand that Israel is a vibrant society in which there is real independence of the judiciary, real freedom of speech, and that is respected and understood. Whether it's understood to the same extent amongst the general public is another matter, because it's a rather sophisticated concept. And in relation to the attitude of the public generally, I fear there isn't a great deal of sympathy for Israel at the moment, partly because of the way in which issues are presented by the BBC and by other news media, which is pretty hostile to Israel. And also, I'm afraid, and we're getting into controversies, you do ask me, I don't think the Israeli government, which has many demands on it, I entirely accept, has as a very high priority putting out its case to the British public, I'm afraid. But we're well away from the subject that we are.
I want to add one. That David speaks in the Lord more than once and really represents the interest, the legitimate interest of Israel. Very nice here sometimes. He's a very important representative. I wish we had for our state people from here doing it, but they done it right.
Well, thank you all for your questions. I've enjoyed discussing with you, as I always do, issues of all nature. Dean, I think that's probably enough for today. Thank you.
Figure out the discussion. That's up to you.